Welcome to the Las Vegas Review-Journal Judicial Primary Debates. Here's your host, Steve Sebelius.
Welcome to the Review-Journal studio. I'm Steve Sebelius. Tonight we're going to hear from candidates for District Court Judge in Department 5. We have 3 candidates here tonight, starting with Veronica Barisan. She is with the Mandarich Law Group, specializing in consumer debt litigation. She's also a pro tem judge in the Las Vegas Small Claims Court. We also have Terry Coffing. He's a shareholder at the firm Marquis, Arbach & Coffing, who specializes in civil litigation. He's also a member of the Nevada State Bar's Board of Governors. And Blair Parker of the firm Cowan, Johnson, Parker, Edwards, who's practiced in personal injury, medical malpractice, insurance defense, and also commercial litigation. And one other candidate who filed for the office, Eric Abbott, declined to participate in tonight's debate. So let's welcome all candidates and thank them for participating. So let's begin with opening statements. We're going to go alphabetically by last name. Ms. Barisich, all to you.
Thank you, Steve. Hi, my name is Veronica Barisan. I am running for District Court Judge, Department 5. I've been an attorney in Las Vegas and Henderson for 15 years. I'm originally from Michigan. I have focused on the areas of general law, civil litigation, family law, and consumer debt. I have had the honor to serve the State Bar of Nevada Fee Dispute Committee as an arbitrator and mediator for many years, as well as the extreme honor to serve on the, to serve as a Justice of the Peace pro tem judge with small claims. I have the unique experience of serving both sides of the court as an attorney and as a judge, and I am ready to take the next step to serve as a district court judge, and I hope that the voters will support me.
Thank you very much. Mr. Coffin.
Thank you. Thank you, Steve. My name is Terry Coffing, and I'm a candidate for District Court Judge, Department 5. Ever since I was a young child growing up in Minnesota, I wanted to be 2 things. Number 1, a professional hockey player like every kid in Minnesota, and number 2, I always wanted to be an attorney. By the time I was 15, it was clear that one of those goals was going to be foreclosed upon me, so I decided to dedicate my educational career to the law. I believe firmly that the law and the study of law is a continuing process, that we start as students, we become advocates, and I'm ready to take the next step to be a jurist. And perhaps at some point in the future take the final step, and that would be teaching. In the 28 years I practiced in Clark County, I am the only candidate in this race I believe that it has the diverse experience of not only the civil and criminal litigation, not only at the state trial court level, but at the appellate level. I believe these qualifications make me unique in this race, and I'm hoping for the support of the voters in come June. Excuse me.
Thank you. Mr. Parker.
Thank you. I am a trial attorney. I've lived in Las Vegas since 1987, representing clients, both plaintiff and defendant. Ultimately, some of those cases end up in trial. I have trial experience of approximately 25 to 30 actual trials as an attorney representing clients. I'm also a short trial judge appointed by the district court to hear cases, and I've heard over 42 trials, actually sitting as a judge with the jury in that. I'm also a judge pro tem for the Justice Court for 19 years. I'm also a court-appointed arbitrator for 20 years, and I've heard over 450 cases as an arbitrator, essentially sitting as a judge like a bench trial, and feel that those experiences have prepared me not only on the representation side, but also as actually sitting as a judge to be a judge in Department 5. Thank you.
Thank you. All right, our first question will go to Ms. Barisich, and it's this. Can you describe your judicial philosophy in plain English?
My philosophy is to listen and take the facts of the case and apply the law. Simple, plain and simple.
All right, very, very succinct. Mr. Coffin?
My philosophy of the law is to, number 1, follow the law and apply it fairly across the board, regardless of the side of which you're on. And I think that makes me unique in this race, also having judicial experience. I was for 7 years as the judge for a federally recognized Indian tribe. I've also served 15 years as a pro tem. And I think during that experience, I have consistently maintained a philosophy that emphasizes efficiency, consistency, and transparency. Thank you.
Thank you very much. Mr. Parker.
As a judge, I'm not an advocate for either side. I'm an advocate for the law. I'm not a legislator, and so it's my duty to follow the law and to share that experience with the attorneys that appear before me. As an arbitrator, I've had experience with, those are selected by the attorneys that come before me, and I've had the privilege of having them choose me and recognize my experience to hear these cases, and so that's my experience.
All right, sounds good. Well, let's go to our second question. This will go first to Mr. Coffing. Do you believe you'd encounter any problem in moving from your current role as an advocate, we just heard from Mr. Parker about that, advocate for a client, to your new role as a neutral judge?
Not at all. In fact, this is something that my family and I have been preparing for a couple of years. I've twice applied for appointment by the governor or for open seats and made it through the judicial selection process as a top 3 in each time. So this is something, again, that my experience, I've already served as a judge pro tem, tribal, and served as a mediator in large cases. So the transition for me has always been what makes a good attorney will make a good judge. And that to me is an emphasis on a diverse background of experience and having the appropriate temperament that can only come with experience to handle the bench.
Mr. Parker, do you think you'll have any trouble transitioning?
No, and in fact, my experience shows that I haven't. I've been, as I indicated, the short trial judge appointed by the district court for over 13 years, where I've actually sat with a robe over at the Clark County Courthouse, hearing cases and jury trials, as well as being a judge pro tem, also as an arbitrator, where I hear cases and decide them, and so I've been doing that my whole career.
Ms. Barisich, it's a different role for sure.
Actually, it is not a different role. I do serve as an attorney, but I am, excuse me, I am a Justice of the Peace pro tem judge in small claims, and I've done that for a few years. So I've had the unique experience of sitting behind the desk and listening to the cases and applying the law. I'm also an arbitrator and mediator with the State Bar of Nevada. So I do feel it would be an easy transition. It's something that I've wanted to do since I've been a child as well. And I think with the experience and knowledge and ability that I can do so.
Sounds great. Well, we will be right back with more District Court Department 5 questions and answers. Stick with us. Welcome back to our judicial debate for Department 5 in District Court. Our next question goes to Mr. Parker. That is this: do you believe all citizens currently have adequate access to the legal help and the legal system? And if not, what could you do in your role as judge to ensure that access?
Actually, I don't, just because of the expense of litigation. Corporations, people who have money, can withstand the wherewithal and the expense of going to court. And so those who don't have the money, that's one of the things I'm kind of embarrassed in as an attorney, is the fees that we charge. And so litigation is expensive, and I think it's important as a judge to try to do those things that use time efficiently and get the cases heard and determined quickly and decisions rendered quickly, so that it doesn't take as much attorney time and trials don't last as long. So I think it's an important part. I think expense is a major part of not having adequate exposure to the courts.
All right, thank you. Ms. Barisich, what do you think?
I too believe that not enough people have access. I think that the court has done a good job with online information, but I do think that might be able to be expanded. I am an advocate for settlement and resolution if possible. So if I was appointed, that is something that I would focus on. Shortening the time that a litigant is in the courtroom and hoping to pursue settlement.
Mr. Coffing?
Well, certainly there are resources out there available that could be expanded to help people have better access to the court, especially when it comes to pro bono work. I'm proud to say that my law firm was the Pro Bono Law Firm of the Year in 2008, primarily based upon a case that I litigated to the Supreme Court and is a reported case. I have a commitment to pro bono that I think I bring to the bench and encourage subtly, as current judges do, taking on those pro bono cases so that the people who are underserved have that adequate access to the courtroom. And that need not be expensive. I too am concerned with the cost of litigation, but we have the facilities, we have the resources. It's encouraging the attorneys to be perhaps a bit more civic-minded and using their precious resources to help people who are so desperately in need.
All right. Our next question to Ms. Barisich first. If you observed a party in your courtroom being poorly represented by an unprepared or an ineffective attorney, how would you handle that situation?
That does happen, unfortunately, but I have not come across that very often. If I was in that position, we would stop the hearing because I do believe that every litigant has the right to be represented to their best ability, and especially if they do have an attorney pro bono or hired. So we would stop that hearing and potentially have continuance if necessary. It would all depend on the facts of the matter. Or we would have a sidebar with both attorneys. But that person, that litigant, would have every right and every opportunity to be represented the way that they should be in the courtroom.
Mr. Coffin?
Well, it's a fine line that a judge walks when they're not supposed to be an advocate for either side, regardless of the quality of their chosen advocate. However, a judge is well within their rights to ask questions of witnesses that may not be being answered or being asked because of the inefficiency of counsel. So that's one way. Similarly, I think, postponing matters to emphasize to attorneys that they do need to be prepared regardless of whether or not their client is rich or poor. That can be done as well. But I'm mindful of the line of crossing over from a jurist to an advocate. And so that I would certainly endeavor to make sure that everyone got a full and fair hearing regardless of the quality of the advocate. And I would do that through subtle questioning and then cajoling as necessary with a counsel.
Sounds good. Mr. Parker, what do you think?
I agree. It is kind of a fine edge. We are not an advocate. We're there to dispense and help justice go forward. I've had that experience as a judge, short trial judge, where I've observed counsel that is ill prepared or not objecting. And again, it's a fine line because sometimes attorneys don't object for a specific reason where they could have, but where it's been so blatant, I've called them up to the bench and had a sidebar with them to discuss that, as well as asking questions myself as a judge can do. But again, it's a fine line. We aren't advocates, and people have a right to choose the attorney and have their case prosecuted the way they want.
All right, sounds good. Well, thanks for your thoughtful answers. We will be right back after this break with more of District Court Department 5.
For all your Raiders news,
veterans on this team.
like us on Facebook, download the Vegas Nation app, and go to vegasnation.com.
Welcome back to our judicial debate. We're talking to candidates for Clark County District Court Department 5. This next question goes to Mr. Coffing. Most judicial candidates say that they will treat all litigants with respect, but describe how you deal with difficult people, whether it be opposing counsel, your own clients, or anyone else in the legal system.
Well, first of all, that goes back to what I was saying about temperament. I believe that 28 years of experience in handling complex litigation of all levels has given me a temperament that I understand the frustrations that can arise in the courtroom. I understand the frustrations that arise between adversaries. And I certainly understand the frustrations of the a party who may not feel like they're being heard. And so number one is patience. You need to have patience, you need to listen, and at the same time, make sure that people understand that you want to listen to the things that you believe to be important. And the things that are important are they're going to be advancing their cases. So explaining that to them on the litigant side is critical. On the advocate side, Certainly, I've seen enough attorneys in the courtroom that believe that overt aggression is somehow a litigation tactic that should be rewarded. I don't believe in that. I'm all for zealous advocacy, but I will make sure that the attorneys that appear before me have the appropriate amount of respect and decorum as is required and expected in a courtroom.
Mr. Parker?
Decorum is important. I think I have the demeanor, as evidenced by my being a short trial judge and an arbitrator, to deal with attorneys and litigants as they have appeared before me. Obviously, litigation is important for litigants. It's their life, and the attorneys also sometimes try to make a show for their clients, sometimes when they aren't as equally prepared or they aren't ready. So it's important to a judge to keep the litigants in control, and also the attorneys, by just reminding them of the decorum of the court and not allowing them to speak back to one another, have them address the judge. And I think that helps, and if need be, call a sidebar with the attorneys to help it so the facts get out and the case is decided on the merits.
Ms. Barisich, how do you deal with difficult people?
Thank you. So I have 15 years experience in the legal field, and as a judge in small claims court, I absolutely have seen some parties that are pro per, not happy, and not happy with each other. And that is a fine line. People want to be heard. They want their time to tell their story. And as a judge, you take those facts and the information that's necessary to hear their story. I think if you show and you act with respect and kindness to someone in the courtroom, even if they are acting a little bit off cuff, they will come back around. So respect and kindness breeds respect and kindness.
All right. Our next question is going to be to Mr. Parker. What do you think can be done to reduce the costs of judicial administration in Nevada, if anything, in your role as a judge?
I think the short trial program is a great start to reducing costs. The short trial program hears cases with a value of less than $50,000, and it's a one-day trial. The rules of evidence are relaxed, so an expert doesn't necessarily need to appear. Oftentimes, experts can charge $5,000, $10,000 to appear for litigation, where the short trial program allows the report to come in. So there's changes and things like that can be adapted, I believe, into just regular litigation beyond the $50,000 limit, which I think will help reduce the costs, as well as putting in a full day's work, a full week's work. Sometimes over there, the courthouse, Fridays are empty, and so having all the judicial days used cut down, I think, the expense.
Ms. Barisich, what do you think?
The court arbitration program and the short trial program, which are both under $50,000, are an absolute good thing to have for the court. It does lessen the judges' calendars for the larger cases. So I would be an advocate of that. Also, hearing and moving the cases through as quickly as possible, and promoting settlement, promoting mediation, promoting discussion between the parties at the beginning and the middle of the case, not waiting until it gets to the very end.
Mr. Coffin.
I might have a little bit different opinion as to how the judiciary can change in order to be more efficient. I've studied this issue somewhat. There are extensive statistics that have been kept by judges that the public is simply unaware of. Time to disposition, matters under advisement more than 60 days, and days in trial. And currently under our system, we don't have a means of enforcing anything. We don't have a means where the chief judge, who has no real authority over the other judges, to go to that judge and say, hey, you're not cutting it here. I'd like to change that. I'd like to see that changed, because, as my colleague indicated, there are times when that courtroom is empty when you don't know why. There are times when matters have lingered on too long on a calendar under advisement. Time is money, and the judiciary needs to be at the forefront of reducing the time to resolve cases.
Along those same lines, this question first to Ms. Barisich, and that is, do you think it's ever appropriate, for purposes of judicial economy, to impose restrictions on what cases go to trial, such as mandatory mediation or settlement efforts?
I do think it is appropriate to initially try that. We should try to settle. We should try to mediate first. And if that cannot be accomplished, then it can move on forward to trial. But I'm an advocate of resolving the matter before it takes too much time of the court or the person, too much money of the person, and trying to get things done as economically as possible.
Mr. Coffin, mandatory arbitration or settlement?
Well, I think everyone deserves their day in court as the Constitution provides. So while ADR programs such as mediations can be encouraged, I do think that there is more utility in making sure the cases that are there are moved along efficiently. Additionally, I'd be an advocate of an early neutral evaluation in which a neutral party looks at a case very early and provides each side with their thoughts and opinions as to where is this going to go and how could we possibly resolve it.
Mr. Parker.
There already is a mandatory arbitration program for cases under 50,000, with the caveat that if a party doesn't like it, they can then do a trial de novo and go back to court. So there is a mandatory. I think it's important to promote a settlement. In justice court, when I've sat as a judge pro tem, there are certain cases that you can refer out. The parties might not want to. They go out and there's a mediator out in the back of the courtroom and out in the halls. They go back there and meet. And it's amazing how many times cases have been referred out there. Parties don't want to go, and they end up coming back reporting that it's been settled. So I would promote settlement discussions in every case to try to get them to the attorneys to seek settlement discussions with a neutral. However, parties have a right to try their case. If they don't want to settle, you can't force them. They can go to trial.
All right. Thank you very much. We're going to take yet another break, and we will be right back after this.
For all your Raiders news,
Veterans on this team.
like us on Facebook, download the Vegas Nation app, and go to vegasnation.com.
Welcome back to our debate for Clark County District Court Judge, Department 5. We are going to hear from the candidates now with their closing statements, starting with Mr. Parker.
Thank you for this opportunity to address the voters. The judiciary is an important part of society, and it only works if there are three things. There have to be good attorneys, there have to be good judges, there have to be great judges, and there have to be great jurors. I've had the opportunity for 33 years to practice as an attorney, representing plaintiffs and defendants, and I believe my experience, that experience in actually practicing law and practicing a trial is important to be a judge, to know what it's like and what requirements of doing a trial. But I think my experience as a judge pro tem for justice court and my short trial judge experience differentiates me from my opponents here today. As indicated, I've been a short trial judge actually appointed by the Clark County District Court to hear a case. I've heard over 42 actual trials where I've sat as a judge wearing a robe over in district court, dealing with litigants, dealing with attorneys, dealing with objections, and resolving cases. I've also, my experience as an arbitrator, I think, sets me apart. I have over 450 cases that I've arbitrated where people come before me, I hear the case, I'm impartial advocate, I'm an impartial judge to decide those cases, and I believe that sets me apart.
Thank you, Mr. Parker. Mr. Coffin.
Well, we talk a lot about in the media about politics on the presidential level, the mayor, the governor, those political battles go back and forth. But the reality is the elected official that's most likely to impact the average person's life wears a robe. Civil matters, criminal matters, family matters. Those are all going to be impacted by a judge. And if you look at the people in this town that we trust in order to vet the candidates such as myself, I think I'm unique on this podium today in having the endorsements of the AFL-CIO, culinary, and the firefighters. People who have taken the time to vet judges. Also, I would urge people when you're thinking about experience, we can talk about experience. I can demonstrate experience. You can go to the library and find the 12 reported cases I have at the Nevada Supreme Court, the 6 that I have in the federal court and the 9th Circuit, all of which I've had the privilege of presiding over from trial through the appellate level on the civil and criminal side. So as far as experience goes, I believe I'm the most well-rounded candidate in this race, and I look forward to serving the public in Department 5.
Thank you, Mr. Coffin. And finally, Ms. Barisich.
Thank you. I have the experience, the knowledge, and the desire to serve as District Court Judge, Department 5. I volunteer in our community. I hold the position of a mediator and arbitrator for the past 11 years with the State Bar of Nevada Fee Dispute Committee. And the past 3 years, I've been honored to serve as Justice of the Peace Pro Tem in the Small Claims Court. I've seen the workings behind and as an attorney. And I know that I can be mindful of the gravity of this position and the effect on people's lives. My name is Veronica Barisan, and I hope you support me.
Thank you all. Thanks to all the candidates for participating. Thanks for watching the Review Journal debate. We'll see you next time.